The fourth and lowest level is negligence, which occurs when the defendant fails to perceive a substantial and unjustifiable risk that the harmful result will occur, and a reasonable person would have perceived and evaluated that risk. A person who is distracted and unaware that they are driving dangerously might be negligent, even though they do not consciously disregard the risk. The significance of mens rea cannot be overstated because it is precisely what separates a person who causes harm accidentally from a person who causes harm intentionally. And our entire criminal justice system is built on the principle that the severity of punishment should match both the harm caused and the intent with which the harm was caused. The third essential element is concurrence, which means that the actus reus and mens rea must occur together, not at different times, for a crime to be established. Both the guilty act and the guilty mind must exist at the same moment or must be part of the same continuous course of conduct. To understand why this matters, imagine a person who gets angry at a coworker on Monday and fantasizes about hitting them, then on Friday, completely forgetting about Monday's anger, accidentally bumps into that coworker in the hallway, causing the coworker to fall and be injured. Although there was mens rea on Monday and actus reus on Friday, there was no concurrence because the required mental state did not exist at the time the act was committed. Conversely, if that same person got angry on Friday, formed the intent to hit the coworker, and immediately carried out that intention, concurrence would be satisfied because both elements existed simultaneously. This element exists to prevent the absurd result of punishing someone for an accidental outcome when they had previously harbored a criminal intent but had abandoned it before acting. The fourth and final essential element is causation, which requires that the defendant's conduct must actually cause the harmful result that defines the crime, and there are actually two separate aspects to causation that must both be satisfied. Cause in fact, also called but-for causation, means that the harmful result would not have occurred but for the defendant's conduct. Using our car accident example, but for the defendant's excessive speeding, the accident would not have occurred. Therefore, causation in fact is established. However, cause in fact alone is sometimes insufficient because it could lead to absurd results extending liability infinitely far. Imagine a person is speeding and causes an accident in which someone is injured. Then in the hospital, a nurse gives that patient the wrong medication out of negligence, and the patient dies from that medication. Using only cause in fact, we might say that but for the speeding, the patient would not have been in the hospital and would not have received the wrong medication and therefore would not have died. This is why proximate causation, also called legal causation, comes into play. Proximate causation asks whether the harm was a foreseeable consequence of the defendant's conduct and whether it would be fair and just to hold the defendant responsible for that harm. In our example, the defendant's speeding might not be the proximate cause of death from the medication error because that negligent medical intervention is too remote and breaks the chain of causation between the defendant's original conduct and the ultimate harm. Causation matters tremendously in criminal law because without it, a defendant could be held responsible for harms they did not truly cause, which would violate basic principles of fairness and justice. The essential element is harm or result, which means that the crime must cause or be defined by harm to a victim or to society's interests. And this element establishes that not every wrong action is necessarily a crime. While tort law covers a broad range of wrongs and injuries, criminal law is reserved for conduct that causes significant harm to important societal interests, such as physical safety, property rights, public health, or fundamental freedoms. Some crimes are harm-based, meaning they require that actual harm occur, such as murder, which requires the death of a person, or assault, which requires injury or offensive contact. Other crimes are conduct-based, meaning they criminalize certain behavior regardless of whether specific harm actually results, such as drunk driving, where the crime is the act of driving while impaired rather than any actual accident or injury that might result. However, even conduct-based crimes recognize a harm element because the legislation criminalizing the conduct is based on the recognition that such conduct poses a serious risk of harm to society. The harm element ensures that the criminal law is reserved for serious wrongs and does not criminalize trivial matters or personal moral disagreements. Now let us bring all of these essential elements together through a comprehensive real-world example that demonstrates how they work in concert to create a complete criminal case. Imagine that Maria, a small business owner, suspects that her employee James has been stealing from the cash register. One afternoon, Maria witnesses James placing cash from the register into his personal wallet without recording the transaction or authorized permission. James sees that Maria has observed him and immediately replaces the money and apologizes. Later that evening, Maria reports the incident to the police, and James is arrested and charged with theft. Let us analyze this scenario through the lens of criminal law's essential elements. First, actus reus is clearly present. James performed the guilty act by taking money from the register without authorization and placing it in his personal wallet, which is the physical conduct that constitutes theft. Second, mens rea appears to be present. When James saw Maria watching him, he immediately replaced the money and apologized, suggesting that he knew what he was doing was wrong and that he intended to take the money without permission, demonstrating specific intent to permanently deprive the owner of the property. Third, concurrence is satisfied because James's guilty mind and guilty act occurred simultaneously as a single continuous transaction of taking the money. Fourth, causation is established because but for James taking the money would have remained in the register, and the proximate cause is clearly satisfied because James's theft directly caused the loss of money. Fifth, harm is evident because Maria, the business owner, suffered direct harm through the loss of money, which affects her property rights and financial interests. However, let us now modify our scenario slightly to show how the absence of essential elements can change everything. Suppose instead that Maria discovers the missing money but never actually saw James take it, and when confronted, James honestly states that he was confused about whether he had permission to take the money because Maria had previously told him he could take small amounts for emergencies. In this modified scenario, although actus reus remains clear, the mens rea becomes highly questionable because James's intent to permanently deprive Maria of the property may not have existed if he genuinely believed he had permission. Without clear evidence of mens rea, a prosecutor would face difficulty securing a conviction for theft, and James might instead face lesser charges or no charges at all, depending on the jurisdiction's specific theft statute and how it defines the mental element required. Understanding the essential elements of crime is not simply an academic exercise for legal professionals, but rather a cornerstone of a just and fair society. These elements exist to protect individuals from arbitrary prosecution and to ensure that punishment is reserved only for those who have committed genuinely harmful acts with culpable mental states. They protect the innocent by requiring prosecutors prove not just that harm occurred, but that the defendant actually caused that harm and did so with a guilty mind. They protect society by ensuring that the criminal justice system is predictable, fair, and operates according to established legal principles rather than based on emotion, political pressure, or individual prejudice. When we understand these elements, we gain the power to recognize when our justice system is working properly and when injustices might be occurring. We become better citizens, capable of serving on juries, capable of understanding and discussing criminal law issues, and capable of holding our legal system accountable to the standards it promises to uphold. The next time you read a news story about a criminal case, you will find yourself analyzing the essential elements, asking whether actus reus has been proven, whether mens rea is clear, whether causation is established, and whether all elements have been satisfied beyond a reasonable doubt. This deeper understanding transforms crime from an abstract concept into a framework that you can apply to real situations. And that framework is ultimately what separates a society governed by the rule of law from a society governed by arbitrary power. The essential elements of crime represent one of humanity's greatest achievements in legal thought, a system designed to balance society's need for justice with individuals' need for protection from wrongful prosecution. And understanding them is truly understanding how the foundation of our civilization is maintained.